Continuing production of The Open Mind has been made possible by grants from the Rosalind P. Walter Foundation, the Bluestein Family Foundation, the Thomas and Teresa Malarkey Foundation, the Garfinkel Menard Foundation, the Center for Educational Outreach and Innovation at Teachers College, Columbia University, the Commonwealth Fund, and from the corporate community, Mutual of America. I'm Richard Heffner, your host on The Open Mind, and today's is the second of two programs with Judge Richard A. Posner of the Seventh Circuit Court of Appeals in Chicago, identified in a New Yorker profile a few months ago as, quote, a flamboyantly candid judicial activist, end quote. Well, now, perhaps you confirmed that for yourselves last time when we discussed my guest's recent Public Intellectuals, A Study of Decline, published by Harvard University Press, and characterized in a Los Angeles Times review as, quote, cornering the market in chutzpah. Whatever, as the kids say. There's so much more now that I'd like to ask Judge Posner about concerning the law and lawyers in America. And if you don't mind, Judge Posner, I'd like to begin with a question that came up in a program with Floyd Abrams, prominent attorney not so long ago. Why lawyers lie? And it sort of stems from the comment that you made about not understanding why knowing that someone is guilty isn't really enough. Why do lawyers lie? Why do they say things that they must know are not true or exaggerate the truth?
Well, the nicest face you can put on it is what an English judge said, that the role of the lawyer is not as a counselor, but in the adversary process as a trial lawyer. Because the lawyer isn't going to lie if he's just trying to advise you on what you should do, you know, how much tax you owe or something. But you're talking about the lawyer as a mouthpiece, as a spokesman for the client. And what this English judge said was that the lawyer's job is to say what the client would say if the client were learned in the law. So if you think that anybody who's accused of crime or who claims that his legal rights have been violated in some way or is a defendant in a civil suit, whatever has dragged him in before the court, the lawyer is simply going to be his sort of articulate spokesman. And since he would, the client, if he knew how to talk to judges and jurors, would be constantly shading the truth to his own advantage, the lawyer does likewise. Now, there are ethical limitations on what lawyers can do. They're not allowed to instruct their clients to lie. And in fact, technically, if you know your client is lying, you're actually supposed to withdraw from the case. But the fact is, of course, lawyers, like actors almost, are constantly advocating positions that they know or should know are unsound or even preposterous.
Like actors.
Like actors.
That's an interesting.
Like actors, because, of course, the lawyer, to be effective, wants to give an impression of sincerity. He doesn't want to wink at the court to make clear his understanding that what he says is just nonsense. But I have found that disturbing as a judge to realize that the lawyers arguing with such passion before you often either know that what they're saying is untrue or misleading, or else they have so identified with their client that they've lost all independent thought and become kind of mindless agents for the client.
Now, is this exacerbated in your estimation by the adversarial system or procedure?
Yes, because in the adversarial system, the lawyers regard themselves as contestants in a game, and they see the judge as an umpire referee. So the fact that there's an umpire in football or basketball or baseball doesn't, it curbs the competitive activity to some extent. Certain moves are ruled out of bounds, but nevertheless, it doesn't really diminish the zeal with which the teams go at each other. So similarly, in our adversary system, the fact that the judge is there to make rulings and try to maintain order doesn't minimize the adversarial fury with which the lawyers go at each other. Now, it's very different in a system, inquisitorial system that they have in Europe, or even the version of the adversary system that they have in England, where the judges take a much more active role in the procedure and curb the lawyers' combat enthusiasms much more vigorously than our judges do.
Which would you prefer?
Oh, actually, I think I don't think it's. I think the answer really depends on the particular culture of the society, and there isn't one. Neither is categorically superior. In the type of system that they have, in the type of inquisitorial system, has, for example, a much larger number of judges relative to lawyers, because the judges exercise a kind of control that our judges don't. Well, in American culture, with its distrust of officials, it's hard to imagine multiplying the judges, tenfold, and cutting back on the lawyers correspondingly.
Do you think that would be a way of achieving what I'll call justice?
There is a widespread view that if you're guilty, you'd rather be tried in the United States, and if you're innocent, you'd rather be tried in Europe, because our system is believed to have a higher rate of error. So because it is more of a contest and less of a sort of more or less disinterested inquiry into the truth.
When this program began 46 years ago, at the first summer hiatus, WGBH in Boston asked me if I'd come up while the program was off the air in New York and put on the program. Then I said, well, we can't use the same title, so we called it Search for Truth. Mm-hmm. And Paul Freund was one of the guests. And after the program, he said to me, Mr. Heffner, you're an innocent, aren't you? You really believe that the law is about a search for truth. In this country, it is not. Uh-huh. And that remains so incredibly disillusioning. But I gather from what you say, Paul Freund was quite correct.
Although it's interesting because I knew Freund quite well when I was a student. And I don't think he went public with what he said to you.
No, this was
So there has
afterwards.
been, there's a kind of conspiracy of silence about the true nature of the legal system, as of most institutions. They're masked from the public by the insiders.
And your feeling, if I'm not mistaking you, is that our approach is appropriate to our history, to our civilization, to who we are as people.
Yes, although I think it could be improved. I think we go too far in making it a game with rules that actually obstruct the search for truth and that make the outcome of the trial much less predictable than it ought to be.
Well, going back to that quote that I offered in the first program we did, that wonderful, wonderful quote in which you said, I'm not fully, so this was in the New Yorker profile, I'm not fully socialized into the legal profession. I'm like an imperfectly housebroken pet. I still have difficulty understanding And this is something that most people get over in their first 2 years of law school.
2 weeks of law
Two
school.
weeks of law school. I said it again. Maybe I think they should get over it in the first 2 weeks of law school. Lawyers spouting things that they don't believe. If someone is obviously guilty, why do you have to make all this rigmarole?
Yes.
Now, is that something you would reflect upon and repeat?
Yes. Now,
Rigmarole. What do you mean
well,
by rigmarole?
by rigmarole, I mean the many procedural hoops that have to be jumped through before an obviously guilty person can be found guilty, or for that matter, an obviously innocent person can be found innocent, because these procedural hoops are also the hoops that someone who has been convicted, maybe erroneously, maybe the time for appeal has expired, and now resorts to habeas corpus proceedings, effort to get his conviction overturned. Now he's going to have to jump through enormously complicated hoops in order to be vindicated. So it's not just a matter of, I mean, I think the guilty benefit more than the innocent from this process, but the fact is it's an obstacle to anybody to have to go through so elaborate a procedure when the actual issues, the issue of guilt and innocence, may be quite straightforward.
What would you do to mitigate those circumstances?
Well, I'd like to see the judges, because a great deal of the procedural superstructure of our criminal justice system, but also of our civil justice system, is created by the judges. This is judge-made law interpreting vague constitutional provisions, sometimes vague statutory provisions. So what the judges have made, the judges can unmake by, I think, being a little more realistic and practical about the what is at stake in these proceedings, and dispensing with, or at least modifying, cutting back on some of these procedural rules that are, kind of traps for the lawyers, for the prosecutors. There's no reason why. It's a curiosity that, I mean, it's more than it's kind of a scandal. The most complicated body of law that judges in the United States administer, not the tax code or the antitrust laws or anything like that. It's the rules governing criminal appeals and criminal and challenge. You mentioned habeas corpus. These are sort of post-conviction challenges to a conviction. This is enormously complicated, even though once a person is convicted and imprisoned, he no longer has a lawyer. And nevertheless, he may have a meritorious claim that his conviction was unjust. Maybe his lawyer at trial was incompetent, but now he'll have to go through the habeas corpus process, which is immensely complicated. He will not have the aid of a lawyer, usually. And if he trips over some of the procedural prerequisites to maintaining such challenges, then he's out. So I don't see why it has to be so complicated. I mean, the basic question is whether a person is guilty or innocent. And yet we get deflected into all sorts of questions having to do with police conduct, character of searches, whether a person's confession implicated somebody else, and whether the confession was voluntary, and so on. So there's just a lot of side issues that gum up the works.
Your feeling then about whether the constable has blundered is that it gets in the way of justice being done?
Yes, there are very complicated rules about when you have to get a search warrant and when you don't, and the rules tend to be porous. So and the result is that there's a great deal of hypocrisy about the system. Although there's a lot of talk about, you can't arrest a person without a warrant, or you can't arrest and search a person without a warrant. In fact, there are so many exceptions that very few, even lawful arrests and searches, are conducted pursuant to warrant. There are all sorts of bizarre things. So suppose, for example, a person is arrested for speeding, and something a little more serious than speeding. Maybe he's arrested and he doesn't have a license. So the police are going to take him off to be booked. And then the question is, what happens to his car? Well, the police have to impound the car, and then they'll search it, and they do what's called an inventory search, so that they can make sure that when they return the car to him, they have accounted for its contents. But of course, what they really want to do in the inventory search is see if there's, contraband, drugs or something. So you don't need a warrant for an inventory search. So it's just immensely, immensely complicated. And if the police are not clever, if they don't know how to avoid these various obstacles, then a guilty person may be sprung, and I don't know what the guilty make of that, to find out that through some incomprehensible procedural technicality, they've gotten away with their crime.
Do you think there is too much of an emphasis in this country on what we generally call due process?
Yeah, I think there is. Although I think it's going to change in the light of the concern about terrorism, because it's when the country feels safe that it indulges in in all these procedural safeguards and an elaborate rhetoric of liberty. And when the country feels endangered, then it realizes that really these are frills and luxuries. I mean, obviously you have to have fundamental procedural protections so that the police and prosecutors don't run wild and intimidate the population. But we've gone way, way beyond that into an area of these and it gets back to this socialization comment. It seems to me a good test of whether a legal rule makes sense is, could you explain it to a layperson in a way that would make sense to the layperson? Could you say, well, we have this rule not because we're just lawyers with complicated minds, but this really serves a social function. I'm going to explain what the social function is. And if you're convinced by that, then I'd say, well, that's a good rule. But if I can only explain a rule by saying that, well, this was the way it was done in the 11th century, and we're very conservative methodologically in law, so we still do it, or we do this because we have a kind of religion of procedural punctiliousness, something like this, or if I say I can't explain it to you because you're not a lawyer, only a lawyer could understand, those would be examples of if that's the best sort of thing you can say about a legal rule. That's a good indication it's a bad rule. So I'd like to see the judges and the legislators and the people who write about law to be more practical and say law is a social tool, and if a particular rule is not serving an important social purpose, ought to be changed.
That more practical, your pragmatism. Your interest in pragmatism relates to your interest in John Stuart Mill, I presume. And that's why he's so intellectually satisfying to
Yes,
you.
Yeah. And this is not the way lawyers like to think, and my advocacy of legal pragmatism has met with a lot of criticism in the legal profession, because lawyers don't want to think that way. And that's the rigmarole that has always troubled me, and I've never gotten over, even though I've been a judge for 20 years now. I've been in the legal profession for 40 years.
But before you used as an example process from the 11th century, what about process from the 20th century or from fairly recent judicial decisions? How free do you feel the judiciary must be to reverse itself, not to stand in its earlier decisions?
I mean, clearly there is an interest in continuity. People adjust their affairs, their activities, and so on to the law as it is. And if it's changed suddenly and unpredictably, you're pulling the rug out from under them, and you're destroying significant reliance interests. So I think there has to be a kind of conservatism or stand-pat tendency in law. That's fine. But when legal rules are clearly dysfunctional, then it's time for them to be changed.
Do you think that judgment can be made outside the realm of political judgment? Dysfunctionality of legal procedures?
Yeah, well, I think many of these are political judgments in the sense that the people for whom, let me take something like the American Civil Liberties Union. There's a kind of, that American Civil Liberties Union represents a position on the political spectrum. It takes the extreme position that civil liberty decisions are kind of ratchet. Every decision that expands civil liberties becomes another sacred writ, and every decision that retrenches or fails to expand is open to reexamination. So I regard their position as political, not as something that's rooted in the Constitution. It's just a political point of view, and I don't think there's anything wrong with judges saying, well, you know, we understand the passion with which you defend the Warren Court's decisions, but we think it's gone too far. We have too serious a crime problem, or we have too serious a international terrorism problem, or we just our legal procedures are just too clotted, too expensive, too complicated, so we're going to retrench. And I think that's the sort of thing courts, especially the Supreme Court, are entitled to do.
It's interesting. You mentioned the Warren Court. Is that the breaking point for you in a general way, which you would say perhaps a pragmatic approach, a modern approach, a functional approach, rather than dysfunctional approach, where you would draw the line?
Yes, I think the Supreme Court in the Warren period, roughly from late 50s to late 60s, really ran wild with a particular vision of the Constitution that I think was far in advance of what people really know about the various social practices affected by the Warren Court's decision, and in advance of public opinion. And so they made the criminal justice process far more complicated than it had been. They also, you know, intervened in the political process and the reapportionment cases in a way that, I mean, you know, did sort of extraordinary things with the back of their hand, like until I think a case called Lucas in the mid or late 60s, most of the states had an upper house that was modeled on the U.S. Senate, in which representation was not based on population but on geography. So maybe every county would have a state senator, even though the counties were of unequal population. And the Supreme Court wiped that out, said that violated the Constitution, and required that state Senate districts be of equal population, just like House districts. So at a stroke of the pen, they changed, you know, these historic institutions, which apparently had been working all right as far as anybody went. I mean, most people are satisfied with the way the U.S. Senate is structured, and that, of course, was the model for these states. So that was an example. I say Supreme Court acting in the name of the Constitution, with no real guidance from the Constitution, but in the name of the Constitution to bring about significant social change without having any sense of what the consequences would be. No one yet knows what the consequences of all this reapportionment has been.
That meant an activist judiciary, or an activist Supreme Court, right?
Well, activist in a particular sense, activist in the sense of stepping on the other branches of government and, you know, asserting judicial supremacy. And actually the current Supreme Court, although somewhat more modest than the Warren Court, and certainly more conservative, has been doing much the same thing in a very expansive interpretation of states' rights, in holding, for example, that federal anti-discrimination statutes can't be applied to state employees. There's nothing directly in the Constitution on that. This is a construct, like the Warren Court, it's free interpretation. In the vision of a kind of abstraction, this is called states' rights. What the Warren Court did was called equality. But I would prefer to see the judges holding their fire until they're confident that a decision changing the law is going to have good consequences.
Talking about good consequences, in the minute and a half we have left, I feel constrained, must ask you for your position, if it's not inappropriate, on cameras in the courts.
Oh, it's certainly not inappropriate. I have generally been opposed to cameras well, let me put it this way. It seems to me it's a decision for every court system to make. And if, state of Rhode Island wants to have cameras in its courts, I don't regard as any business of mine. But so far as my court is concerned, I would be opposed to cameras for several reasons. One, the most parochial, perhaps, is I don't really want to become I want to be that recognizable. Because judges are sometimes unpopular. We receive threats at times, so we want to be able to walk around the streets without people recognizing us. That's petty. But one worries about acting up in front of the cameras on the part primarily of lawyers, but of judges also. So that's
thank you. Thank you very much, Judge Posner, for joining me today on The Open Mind. And thanks, too, to you in the audience. I hope you join us again next time. And if you would like a transcript of today's program, please send $4 in check or money order to the Open Mind P.O. Box 7977, FDR Station, New York, New York 10150. Meanwhile, as an old friend used to say, good night and good luck. Continuing production of The Open Mind has been made possible by grants from the Rosalind P. Walter Foundation, the Bluestein Family Foundation, the Thomas and Teresa Malarkey Foundation, the Garfinkel Menard Foundation, the Center for Educational Outreach and Innovation at Teachers College, Columbia University, the Commonwealth Fund, and from the corporate community, Mutual of America.